Good day. Welcome to Lawyer Up by NDV Law. This is Attorney Nikki de Vega, the managing partner of Nicolas and de Vega Law Offices. In today's video, I will teach you how to properly tender a resignation in your company. If an employee is unhappy with his work or would like to seek greener pastures, the normal recourse is to resign. The Philippine Supreme Court has defined resignation as the formal pronouncement or relinquishment of a position or office, and it is the voluntary act of an employee who is in a situation where he believes that personal reasons cannot be sacrificed in favor of the exigency of the service, and he has then no other choice but to disassociate himself from employment. In illegal dismissal cases, it is an elementary rule that when an employer interposes the defense of resignation, he bears the burden to prove that the employee indeed voluntarily resigned. Thus, the acts of the employee before and after the resignation must show the intent to relinquish together with the overt act of relinquishment. There is also a proper method of resigning. A text message or letter signifying the intent to resign effective immediately is not the proper way of resigning under Philippine labor laws. Article 285 of the Labor Code of the Philippines states that an employee may terminate without just cause the employee-employer relationship by serving a written notice on the employer at least 1 month in advance. The law further states that the employer, upon whom no such notice was served, may actually hold the employee liable for damages. So take note of that. Regarding the 1 month advance notice, it was explained by the Supreme Court in the case of Hechanova versus Matore that the 1 month notice requirement for an employee's resignation is actually for the benefit of the employer. This will afford him enough time to hire another employee if needed and to see to it that there is proper turnover of the tasks which the resigning employee may be handling. Since the 30-day notice is for the employer's benefit, he may waive such period. Thus, he can actually shorten it to say 15 days, 10 days, it depends on him. Take heed that if an employee does not give the 1 month notice, he can be held liable for damages to the employer. An aggrieved employer may file a case for damages and breach of contractual obligation with the regular courts. Nevertheless, not all resignations require advance notice of 1 month. Take note, the following grounds under Article 285 of the Labor Code are considered just causes, allowing the employee to resign immediately. Number 1, serious insult by the employer or his representative on the honor and person of the employee. Number 2, inhumane and unbearable treatment accorded the employee by the employer or his representative. Third, commission of a crime or offense by the employer or his representative against the person of the employee or any of the immediate members of his family. And fourth, other causes analogous to those that I mentioned previously. It must be borne in mind that the resignation is complete upon acceptance by the employer. Thus, an employee must therefore be careful and circumspect in filing his resignation, because if he changes his mind, he needs to reapply for the job, as held by the Supreme Court in the seminal case of Intertrod Maritime Inc. versus NLRC. Well, like any separation, severance of employer-employee relations is a difficult process. However, before parting ways, it is prudent to follow the procedure laid down under the Labor Code, not only for the sake of complying with the law, but also to maintain cordial relations. As the song goes, it's a small world after all. Thus, burning bridges by leaving a bad impression with a company may be prejudicial in the future. Well, if this video has been helpful, kindly subscribe to our YouTube channel by clicking on the subscribe button. You can also visit our website, ndvlaw.com, to learn more about legal matters in the Philippines. Again, this is Atty. Nikki de Vega, and thank you for watching Lawyer Up by NDV Law.